to start the meeting?
Morning, Chair. I thought we'd give another minute or two for some members to join us.
Oh, okay. All right.
7 on the platform.
Okay. Debs, you are early.
No, I'm always on time.
For a change.
Marina, you don't have to
For
respond.
a change, Honorable Matlingos.
Don't
That's not
do that,
taboo.
Honourable Member. Don't do that.
That's no taboo.
Yes. Hey, Ringo, why are you always on my case?
Oh, Tevino.
Oh, my brother, how are you?
It's a sharp.
Chairperson, if I may, I will hand over to you. We have 7 members on the platform. Sorry, 10 members on the platform. Thank you.
Hi, Dwayne. You can do a roll call for us, please.
Thank you, Chair. I have yourself, Honorable Minko Gigaba. I have Honorable Adjourns, Honorable Morwane, Honorable Letsie, Honorable Morwa Shetla. I have Honorable Nodada, Honorable Van Zyl. I have Honorable Madlingozi. I have Honorable Sukers and Honorable Boshoff. Chair, there was just an apology from the department side. Minister won't be able to join us this morning, but I think Deputy Minister may be on the platform already. Thank you, Chairperson.
All right, thank you very much. Let me greet everybody. DM, morning, and Team DBE. Morning to the members, all of them that are in the meeting.
Chair,
And,
morning. Let me come in before just to extend the apology of the minister. There's a budget council today, and she's chairing the budget council in the treasury. So she might not be part of this meeting unless she finishes earlier that side. Thank you.
Okay, all right, DM. Thank you very much. Morning to our staff and to everybody that has joined our meeting. And welcome. Let's thank you, members, for heeding to the call of having this meeting. We know it is constituency period. You obviously have constituency work to do. But I think we need to thank you for allowing us to proceed with this meeting, which we promise it's not going really to take a lot of your time. Can you flight the agenda for us, Gordon? Okay, thank you. We are supposed to be dealing, all right, the the apologies, I think we do accept them. We're supposed to be dealing with the consideration and adoption of the BELA bill as amended, together with the draft committee report. And after that, we are going to consider and adopt the minutes of the 12th and the 19th of September. Can I allow members to agree to the agenda as presented? Debza, Honorable Itzia.
Good morning, Chairperson. Good morning to all honorable members on the platform, the Deputy Minister, the team from the department, and observers. My name is Tebo Kholitsi, and I move for the adoption of the agenda as presented. Thank you.
Your father.
Modula studio Maloko Kamoka at this all-important portfolio committee on basic education, Deputy Minister, departmental officials, led by His Majesty Remweli, and the staff members. Erikemelele, on behalf of myself, and also in support of my beloved son, to second the adoption of this agenda as is. Thank you.
No, thank you very much to both of you, Honorable Itzia and Honorable Murwatsetla. The agenda is now adopted. Just to take members to 2 weeks back, where we had the last deliberations on the BELA bill. We had agended the meeting that time. Had been agreed that we are going to meet the following week, which was last week. Because we would have wanted the bill to be finished and for us to have the draft, but we could not do that last week. We rather had a meeting on the exam readiness. We are now reconvening, and we are reconvening with the idea that we are going to look into the B2 bill and the insertions of the A list that were done by the legal people. And then after that, we will be able to move and adopt the bill as sent. I trust and hope that members had an opportunity to go through it. We have also attached the what are these things now? We have seen part of the attachment on the emails that you were sent is the spreadsheet, which is drawn from the matrix that were given. It is just an attachment for members to take note of. I must say upfront that you would see that the names of the people are not really mentioned except for the organizations. We have done that to protect the names of the people as the Copia Act prescribes. But then that is the spreadsheet for that. Now, as we are going to proceed today, we now that we have done what we think we were supposed to have done, We have done the A list. We have adopted it. We have asked the team of legal to insert
Recording in progress.
of the A list to the B2, which will ultimately give us the BELA bill as drafted. Now, our approach is to give members, of course, to speak to that process an opportunity. Whether we do it by party, to allow members to speak on the process, and also to speak on the insertions now that have been made to the bill, which of course will ultimately lead us to the adoption of the process. So I'm opening a space for members to speak, like I've said, whether they would speak per party or rather they would speak as members of the committee in whatever way. And I see that there are no hands. So let me give to Honorable Nodada. Honorable Madlingozi.
Good morning, Chair, and good morning to everyone on the platform. Chair, I just wanted to check which part of the agenda are we on now, so that if we have to make any inputs, I understand on what agenda item we're on now, and what inputs are you requiring from us? Is it based on the agenda itself of the B list that has been presented, on the report that has been sent to us, on the matrix? Which part of the agenda are we on now, so that I can, when I make the inputs, at least I understand what you're requesting of us? Just a clarity second question.
Llewellyn, can I ask you to flight the agenda again? Second column, where it starts from 9:45 to 12:30, it says consideration and adoption of the Basic Education Laws Amendment Bill. We are on this part of the agenda. On this part of the agenda, like I have said, members have received the draft bill, and I'm asking members to input on the draft bill, not unless you would want the legal team to take us through the work that they have done. If perhaps there are things that you think that they must be presented by them. That's where we are. Thank you, Llewellyn.
Thanks, Chair. I think, Chair, for the purposes of consistency, I think that the team must present like they've done with the A list. Let them do the presentation to us, and then, like you normally do, take our hands, and then we take it from there. I think it would be the best way to deal with it, Chair, despite the fact that you may say we've received the documentation. I think their explanation of each of those changes will make sense to us. It may not necessarily be the whole B list, but where the changes have been, and we then follow that process just as a meeting procedure, Chairperson. Thanks, Chair.
Honorable Madlingozi.
Chairperson, thank you very much. I would propose that we carry on with the plan and the processes as you have alluded, because I believe that what we are supposed to be doing now is what was postponed because of the time frame that was given to us at that time. So we are going to be talking about what we have been discussing anyway, and for the legal team to again repeat what they did. I think it's the waste of time, is to say the least, Chairperson. So we can carry on and talk to the bill. Thank you, Chair.
Thank you, Honorable Boshoff.
Thank you, Honorable Chair. Maybe I want to agree with Honorable Mandlingozi. As I understand, we should make final statements as members of this committee on the bill as it is in front of us. The process has gone to this point, and well, I'm ready to respond to the bill from my party's side. Actually, I also would just like to have clarity on exactly when to do that. Thank you.
Thank you very much, Honorable Principal.
My chair, and once more, everybody on this all-important platform, I think we need to recap and agree that we are where we are because of the concerns raised by some of the committee members that there is an omission on some other important processes which are supposed to inform the bill, draft bill at our disposal. And we have covered that ground. We requested the people and together with the legal team to work by way of infusing all whatever might have been omitted. Now it has been inserted therein and together with the spreadsheet that we have been referring to. Now, what is expected of us as members is we got this report quite well in advance, is to go and highlight those areas of concerns which were initially made in our last meetings. For us to come and say we expect the legal team to represent this report or this draft bill, I think it will be an unnecessary exercise. With all what has been said and done from my side, I want to support Honorable Mandlingozi, my beloved brother, and I also want to support Honorable Boshoff, my other beloved brother. Thank you very much, Modest.
Well, thank you very much, members. Let me probably speak this very slowly. The last meeting we had 2 weeks back, members must recall we were adopting the A list, which we therefore asked the legal team to make an insertion of that A list to the bill. What made us not to sit last week, what we waited for them to print the bill, which is what we received. So I don't know if you want me to say they must present what? They must present the insertions which we have adopted in the A list, or what is it? And to respond to your question, Honorable Boshoff, that is what exactly I was asking. I said, I'm asking for the parties to speak or members to speak on the bill because that is what we are supposed to be doing. But because of we are a nice committee, let me ask, I'm not sure, Advocate Ngema, whether you can just briefly say what is it that you have done with the insertions of the A list to the B2. Because I think that process, maybe if it's said by your English, it's going to be understandable. Thank you very much. Advocate.
Greetings to the honorable members. Thank you, Chairperson, for
Sorry,
the
Chair,
opportunity.
before Advocate Ngema comes in, it's a point of before, Chair.
Thank you very much, Honorable Letsie.
Yes, Chair. Chair, there are 4 members who spoke. 3 of them said there is no need for legal to speak now. So I'm not sure if you are overruling the 3, Chair. Honorable Boshoff, Honorable Mandlingozi, and Honorable Moratsetla, who says, this is not where we are supposed to, or this is not what we are supposed to be doing. So are you overruling them, Chair, or I just need clarity there?
I'm making things easier for all of us. Akiri, we are coming from a long weekend. So we might have forgotten where we were, and a lot has happened this weekend. People got married. You don't know whether people's were taken or what. So we must at least show
Yeah, but
mercy.
we can't be dictated
We
by one
must-
person.
We must show mercy. Advocate Ngema, okay, it's fine then. Now I just want us to show mercy. Can I ask the ANC to speak on the bill? Probably that's what it's going to.
Point of order, Chair.
To who now? To me?
Yes, on you, Chair.
What have I done now?
Point of order, Chair. Chair, procedural, you know very well that you make a ruling. Now, I don't know when your rulings have become questionable, unless some people raise it, and then you change your rulings. You've made a ruling here that Advocate Gamma must present. Somebody raises their hand to challenge your ruling. And when we've done that in the past, we've been ruled out of order, Chair. So I don't know.
No, but also Akiri Litsia called me to order, which is correct. And really, I was trying to be sympathetic to you, but then he realized that and called me to order. So let us please be procedural, my brother, all of us. Can I ask
Yeah,
the
but
ANC to speak on
okay,
the bill?
it's fine. It's okay.
Honorable Adwans, are you speaking on the bill?
Good morning, Chair. Before I speak to the bill, Chair, let me greet all the honorable members, the DM, the officials from the department, the legal services, and our staff. Good morning to everyone. Chair, I think it will be proper. I know you made your ruling, but I thought maybe you would give Ms. Ngema just to give us a few pointers whether we agree to continue with our own comments as political parties or not. But let's hear what she has to say. I hope it won't take long, because already we've dealt with the adoption of the A list. I think you made a comment that we hear the insertion of some of the things that we have agreed upon, and how is the bill looking now. I think it is important to hear that, so that when we continue closing, we know that there is nothing that we have left behind. I would humbly request that we give Ms. Ngema just to say what she wanted to say, Chair. Thank you.
Okay, now it's 3-2. Probably I must now make this ruling that, for purposes of the long
My chair is put at a corner.
I repeat, for purposes of the long weekend that we are coming from, people have really forgotten where we are. And, let's agree and be sympathetic to them. Advocate Ngem, can you just speak on the A-list insertions to the bill? Thank you.
Oh, you're overruled by one person now, Chair. Okay, it's fine.
Pathetic to you.
It's a long weekend.
At the end of the day, at the end of the day, we need to adopt this bill.
And
whether who's wrong and who's right. I'm making a ruling because I can see that there's a serious confusion between yourself and Adwans. And I understand, comrades. People were getting married. I said, the two of you, we don't know, maybe your people were taken this weekend. It was just 2 pieces. So let us be sympathetic.
He's calling me somebody, this is not that.
To every point. Okay, Advocate.
Thank you once again, Chairperson, and greetings to each and every one of you, the honorable members. and everyone in the platform. Chairperson, with your permission, may I proceed without flighting any presentation and my video, because I did not prepare anything for the presentation, but I can speak to the request as indicated.
Actually, Nam, that's what I said. Probably people want your English, so let's allow you to speak your English.
Thank you, Chairperson. May my English carry me through. Chairperson, what basically we have done as the support staff to the committee and the state law advisor was to take the deliberations and the instructions of the committee in terms of what should be amended and dealt with in the bill that was introduced by the executive. So the presentation of the A list that was done by my colleague, Advocate Van Breda, has been incorporated into the B version bill, which is B222, which is called the B version because it changes from what was introduced by the executive into what has been considered by the members after being influenced by the public submissions, public consultations, and their own deliberations that have taken place. Under clause 1, Chairperson, what we basically did was to address the issue of basic education, which initially was defined as meaning grade R to 12, but due to what the Constitution is stipulating, we have changed means into includes so that it aligns with the Constitution, because our Constitution is the supreme law and whatever at least is dictated there must be respected and followed. The second definition under clause 1 that we addressed was the definition of competent assessor, as well as the definition of special education needs, Chairperson. It was corrections as per the discussions already and the responses that the department gave. Under clause 2, Chairperson, the amendment that we had for purposes of clause 2 was to correct that confusion that would have been created in respect of what age should a grade R learner be. So that correction is now effected as it could be seen, as well as correct the school activity use of the word and the term defined into official educational activity of a school when dealing with matters that relate to the admission of grade R children. Under clause 4, Chairperson, it was a cleanup in relation to the required documents, as well as what was expected to be done with all those departments that were included to form the structure that would assist in gaining those documents. So it was a cleanup, Chairperson, that relates to the admission policy as well as the required documents. Under clause 5, yet again, it was a cleanup because clause 4 and clause 5 were one of the most contested provisions in the bill because they deal with the powers of the HOD and the powers of the school governing bodies in respect of the language policy and the admission policies. So after all the deliberations and considerations of the views, Chairperson, what was promised and indicated that there should be a cleanup and clarity of what is exactly happening here and what is confusing as raised by the submissions and the public hearings of people that came to those processes. So there has been a cleanup, Chairperson, and those provisions are clear now to say what is expected, what are the requirements, and what is the process to follow when engaging in those two legal processes, the determination of admission and language policies for the public schools. Then we move to clause 5, Chairperson. Clause 5, I've already dealt with clause 5, Chairperson. We then move to clause 8, which also has been corrected Clause 8 is the clause that was dealing with enabling alcohol to come to our schools, and we had an overwhelming objection to that provision. And so what happened, Chairperson, was also a cleanup and the removal of that provision, which was enabling the principal to address the issue of request to bring alcohol into the school premises, whatever may have been the reasons for making such a request. So a cleanup has been done in respect of clause 8. And if you read the B-Bill version, it is very clear what then had to come out and what had to stay behind. And we have done the consequential corrections in order to ensure that it reads in lines with the conventional for drafting purposes. Clause 9, Chairperson, is a clause that was seeking to amend section 9, but what we corrected there as per the deliberations is that there was a use of word suspected, and we changed it into accused, because at least with the accused word being used, it is clear that there are already processes that have been started to justify that a person may be dealt with. So there is a process that must go on, and then it deals with the suspension of that learner who may be accused of having done the wrong as per the amended section 9. Clause 14 and 15, Chairperson, they were both removed as per the deliberations of the committee. It was those dealing with disclosures of financial interest for the members of the SGB, and the one dealing with the central the use of school facilities. So both 14 and 15 were rejected. That is why they are no longer as part of the B-Bill version. And because of the removal of those provisions, the consequential amendment which members may pick up is that the number is then less from the 56 provisions that the original bill was, into a number that subtracts 14 and 15, and therefore the numbering of the bill provisions, the B version, have also been corrected, and that's what you see in the B bill version. Under clause 22, Chairperson, we also, because of removing that part which was dealing with the disclosures of financial interest for the members of the SGBs and their families as per the initial bill, we have then, as per the discussions, corrected or inserted under clause 22 that excuse me, that at least in addition to personal interest, the members must also disclose or indicate when the meetings take place where they would have personal and financial interest. That is the change effected under clause 22. And then under clause 30, Chairperson, clause 30, the initial clause 30 was amending section 38. And what was basically to take place there, which is no longer taking place after the other meeting that was discussed, is that the department did indicate that in terms of their programs and the way that they are structured, they do not have sufficient time to enable days that are inclusive of a month where a specific legal action is required. Hence, they requested that instead of what the members had indicated, that it be 30 days, we revert to their 14 days. So there will be no more changes that are done into clause 30 because exactly of the submission that the department made after the initial presentation of the A list. Clause 37, Chairperson, is the one that is on home education. There was also very overwhelming discussions and contributions into this provision. And after discussions, Chairperson, what was mostly contested, which is the interference with people's right to dignity, and the section 29, which requires that home education may be permitted, however, there is a need for registration, which transpires and is demanded out of the Constitution itself. So what we have done is to ensure that there is compliance with the Constitution in terms of the right to dignity, as well as the right as well as the requirement that home education, because education to every child is a basic right. Therefore, they must be registered so that the state is aware of what is happening and that the child enjoys the right that is conferred upon them. So there are changes there which basically removes the issue of having to go into the private space of the education that is done from home and the houses of those children that are being taught back at home, as well as to ensure that there are competent assessments that are done to keep up with the requirements and monitoring that the child is progressing as it should, and that the education that is required is given to the child. So those are the changes that have been effected under clause 37, which was dealing with home education. And then, Chairperson, it is clause 41. Clause 41 is the one that's amending section 61. In respect of making the regulations, we were asked to ensure that certain parts of the regulations are brought before Parliament for purposes of tabling, and that is exactly what clause 41 does. And then eventually, because of the agreed changes and the effected changes, there are consequential changes that had to take place with regards to the long title, as well as the memorandum of understanding, which is found at the back of the bill. So those two have also been corrected, and the last change that members would see on the A list are the changes that correct the long title, which is the first part of the bill that explains what exactly are the changes that are sought and are being effected into the existing Principal Act. And therefore, the memo is also consequentially corrected, but that appears on the B bill versions. For example, where clause 13 and 14 are being removed, that is removed, and we do the corrections in light of the other provisions that have been changed. For example, clause 8, which was to remove the enabling allowing of alcohol into the schools. So that is basically what has happened, Chairperson, and what we have done into the CRIDA processes, of which the B bill version is before the committee as a PDF document, as well as the A list, which is no longer now a word perfect document, which we did, but a PDF document that is ready and has been circulated for public consumption. Thank you, Chairperson.
Thank you very much, Advocate Ngema. I think now Advocate has made our things a bit easier. I'm not sure whether you would want Llewellyn to flight now. What really the bill looks like, in understanding that maybe other members did not even check their emails. Principal, I see your hand is up.
Yeah, thank you very much, Chairperson. I think finally, let's say we give you the benefit of that you might have taken the right, what you call, approach by giving her space. But can I make a humble request, Chair, that she was talking to the B version bill, which at the end of the day, once adopted, which will become the draft bill which will be presented to the National Assembly. But this input of advocating is very critical and very important. Can we say, now that she has orally presented this, we request her, because it will be part of the records of the minutes, we request her to contextualize this input in the form of a separate presentation, so that we know, I know it will be recorded, but is it possible that she writes it down so that in future, apart from going into the records electronically, we will be able to say This was her presentation. I humbly request that, and I know why I'm doing so. Thank you very much.
Honorable Notata.
Chair, I just wanted to check, are we able to ask just clarity-seeking questions? Because I know that you made a request that we must make an input on the bill itself. But the reason why, initially I had requested that she does a presentation so that we're able to pose questions before we're able to make those statements. So I just need to be guided by you, because there's one or two questions that I would just like to ask, because we've obviously made an analysis of what was on the A version of the bill versus what is on the B version of the bill. And there's certain questions that we have with, that have a level of uncertainty when it comes to legal terms. So, I just wanted to get your guidance on that, whether can we pose those questions to Advocate Ngema now, or do we just make our submissions as a submission, as you've requested, our statement on the B version of the bill? So I just need to be guided by you on that. Thanks, Chair.
You see, now my understanding is that we have adopted that A list which they have inserted, and that's what I'm saying for the third time now to this B2 version bill. But Advocate Ngema, because I'm worried now, we are shifting this meeting to another direction. I don't know, but we are shifting it to another direction. I'm not sure whether now you would say, oh, Advocate Ngema, they have missed something in their insertions from what we have adopted or what we are saying. So with all due respect, Honorable Notata, before this meeting shifts to a particular direction, can I give a directive that says probably you can give that to us in writing? Please give that to us in writing. And then can I ask parties to speak on this matter? Honorable Sukers, your hand is up.
Yes, Chair. I think good morning, Chair, and good morning to everyone on the platform and our colleagues. I think you've touched on it maybe with the last sentence, because what I wanted to ask is, based on what was presented now by the advocate, if we can update our minority report to then reflect what our responses to what was presented. Thank you.
Okay, I've responded to that, but also to say to the meeting, the provision for minority parties to raise their views on top of what would have been raised now. They can still write their issues. But what I'm saying now, this opportunity that I'm giving you to speak is to speak to that as well. I'm giving members opportunity to speak so that you also, if you think that now the insertions are wrong, it's issues that you can raise here as well. That is the opportunity I was giving you when I started the meeting, which I probably think many of you did not understand where I was coming from. So let me allow that opportunity now for parties. What you would say in Parliament is a declaration to speak, and this we would allow for even 5 minutes for parties to make their declarations on this process. And also, like I'm saying, there is a provision for minority parties to also write if they feel like writing. Your hand is up, Honorable Madlingos.
Chairperson, you are giving me time to talk.
That's where we are. Please, can you lead, fighter? Maybe if we are led by you, we will be directionful.
Thank you, Chairperson. Let me again welcome the re-presentation by Advocate Ngema. We really would love to have heard your English once again. I would love to welcome all the department officials, my colleagues, the visitors. Thank you, Chairperson. Chairperson, the EFF is in support of the amendment to the South African Schools Act, which seeks to make education compulsory from grade R to grade 12, and the criminalization of anyone who blocks children from attending schools without a just cause. Taking into consideration, Chairperson, that schooling cannot be in a nappy-changing environment, we would love, excuse me, to want to have the age of entry into school to be lowered to 3. This is particularly important now that the nursery schools are being transitioned to the Department of Education. We particularly support the clause that emphasizes the need for the department to intervene in ensuring that school governing bodies do not discriminate learners when developing admission policies. Chairperson, EFF does not support the idea of SGBs be given unlimited power to determine discriminatory policies without check and balances. It was primarily for this reason that in our 2019 manifesto, Chairperson, we advocated that each school must have its own social worker to deal with problems such as these and to understand the social problems that lead to many learners dropping out of school. Chairperson, this provision is progressive in as far as making school attendance compulsory. We also submitted that the enforcement of this must not be the sole responsibility of principals and SGBs. The department must appoint qualified social workers to deal with the issues in every school. We are also in support of the powers to be given to the heads of departments as HODs to make their final determination on the language policy of the schools. This function cannot be left to the SGBs, as many in the previously white schools still use language to exclude many Black children. We further submit that standardization of languages should be centralized in the department and not different HODs from different provinces. The same logic must apply for code of conduct for all schools. This function must be centralized in the department, not SGBs. This is particular in the Western Cape, Chairperson, where Afrikaans is used to exclude African learners. We are completely in agreement with the total deletion of Clause 8, which deals with the sale of alcohol in our school. On the amendment of the Employment Act, on the amendment to the Employment of Educators Act, we are in full support of the amendment that prohibits educators from being in any business with the state. We also want to a more stringent legislative approach on school admission policy. The admission policy must be that of the department, and the schools must not be given as much power to exclude learners on the basis of flimsy criteria such as where the learners are coming from, where they reside. On the disciplinary hearing, we submitted that learners should be able to bring in parents as their representatives. There should not be a case where a child is facing disciplinary hearing without the presence of a guardian. Making schooling compulsory for all school-going children is a necessary intervention to ensure that no child is out of school, Chairperson. This, however, does not address societal problems underlying the absence of some children from schooling. The bill makes no provision for the kinds of steps that may be taken in instances and where one child is forced by circumstances to take care of a sibling or a parent. There must be provisions for collaborative work with social development to ensure that school hindrances to school attendance are addressed, prioritizing the interest of this child more than anything else. Chairperson, the same concern applies to the provision that makes it responsibility of the principal to check up on children who are not attending school. This is not going to help with a high dropout rate in public schools if the focus is not on dealing with the social problems underlying these high dropout rates. The provision relating to language are absolutely necessary, as many schools that are previously white-owned use the language, particularly Afrikaans, to exclude Black learners. With all these concerns addressed, Chairperson, the EFF is in support of the bill. Dabule.
Game on.
Thank you very much, Honorable Matlingozi. I think you understand where we are. Can I give to you, Honorable Boshoff? You said you were ready. I
Yes,
think the
thank you.
members don't understand where we are. Honorable Boshoff, thank you.
Thank you, Honorable Chair. First, may I give recognition to the hard work that many people have done since a new amendment bill for education was raised the first time in 2013, which is about 10 years ago now, if my mathematics serves me well. And may I say that there are some things that has happened in between which may have not been sufficiently taken into account, but one should give recognition to the hard work in order to have a legislative framework which attempts to keep up to date and to provide the best schooling possible to South African children. However, it's not possible for the Freedom Front to support the BELA bill, despite some good features in tidying up some provisions. And maybe I could point out the critical deficiencies. In the first place, we are fundamentally opposed to the idea of a state school in opposition to the community school, where the South African Schools Act as provided in 1996 for community schools and not state schools. There was a gradual slide towards state schooling opposed to community schooling, and that is legislated into law if this bill is accepted by all the houses of parliament. On a more practical level, one can say that online education is not sufficiently taken into account. The whole revolution, and I do not hesitate to use that word, in education brought about by COVID-19, or maybe I should say it wasn't brought about by COVID-19, it had been around for much longer than that, but it had been forced to the foreground with the pandemic and the resulting lockdown. That has not been taken fully into account, and that is a rather fundamental flaw in this bill. Now, there are some references to the constitutional sections having an influence on this bill, but no reference is made to Section 235 of the Constitution, referring to self-determination. Now, according to several international treaties on self-determination, which was also accepted by the South African government after 1994, education is at the core of cultural survival, and cultural groups should be afforded full responsibility and the opportunity to look after their own education. Now, this right is fundamentally eroded by the BELA bill, exactly for the reasons why the freedom fighters have just mentioned that they support the bill. Not saying, it's an attempt to discrimination. I don't want to give that credit to what the fighter have just said, but the idea of a centralized state-driven educational system. In fact, what should have happened with the new education law is not more state control but less, because at the moment school governing bodies are in control of the management of the business affairs of a school, but the curriculum is squarely in the hands of the state, and even that should be decentralized, and the responsibility given to communities, especially cultural communities, with all the rights implied with Section 235. In terms of homeschooling, I think that the public participation process did a lot of great work. The homeschooling community was very well prepared and participated in a thorough way in the participation process, and it led to some improvements in what had at the outset being planned by the bill. However, in the last part, there is still the provision that the minister can formulate regulation on his or her own, which in fact, despite all the different concessions made, still gives the minister unfettered rights, which is not a good thing, if I may put some emphasis on that. Therefore, if one looks at the amendment bill, the Basic Education Laws Amendment Bill, one could, stare yourself blind into some good provisions, making some provisions in the law more rational and easier to follow, but the fundamental flaws in this act or in this bill cannot be supported by the Freedom Front, and will oppose it in every way at our disposal in the process following from today. Thank you, Honourable Chair.
Thank you very much, Freedom Front Plus. Any other party that wants to speak?
Honorable Chair, it's Honorable Sukas here. My apologies. I just have one challenge that I'm trying to sort out, Chair. If you can just give me 2 minutes, please. I'm under pressure with my electricity, and my phone is going to die. So I'm just needing to get something sorted.
Okay. No data? Now, what was no data? Is your hand up or down?
Am I audible, Chair?
Yes.
All right, cool. Chair, thank you so much for the opportunity. Believe you me, I know exactly what is happening with the process and where we are, despite the side comments and the illusion. And
We've lost you now. No data? We have lost you.
It's because he's answering things that he's not supposed to answer to. Network does not like that.
No, he's still preparing the notes of what to say, because the truth has been laid fair.
And again, please, people. I am on his defense today. Marina, should we leave the DA?
No, they must speak. That was your call.
But we have lost him totally, I think.
Chief, Honourable Van der Walt, maybe if there's another speaker, let them go first before Nodada, because I can't speak on behalf of him. I'm not sure what he was going to say, or Honourable Van Zyl. So I think, I'm not sure if there's another speaker before you want to step down from this.
They're busy with minority reports.
No,
well,
but leave the minority parties to do their thing. Now I don't know what to do because Sukar said asked for some ANC. Is the ANC ready? Not ready. The ANC is also not speaking or what?
No, the ANC is going to speak last through our whip. Let them talk.
They are not here, so I don't know what to do.
I'll let the next party go, Chairperson.
Which party? It's yourselves. Well, you are both busy.
Well, I can't speak on behalf of a colleague. I don't have his notes, and we actually do come prepared with our own.
Chair, I don't know what happened there, Chair, but am I audible now?
You were lost. Can you quickly get to on train before it leaves you again?
All right, Chair. Just Chair, please indicate to me when I'm not being audible. Can someone get this foot? Chair, I was saying that.
I did that.
All right, cool. Chair, I was saying that as the day in its current form, we unequivocally reject the BELA bill. And I emphasize the point, its current form, because there's some provisions that are being made into law that we completely do not support from a principle perspective, a legislative perspective, and a policy perspective. The DA supports educational reform, especially given that the current state of basic education system is completely broken at the hands of the state, particularly for children that come from rural areas like me in Solo that are receiving a broken education system. But the BELA bill fails to even address the major reasons South Africa's lack of quality education exists. Instead of addressing overcrowding, curriculum failures, dropout rates, unsafe environments in schools, unsanitary education facilities, poor quality teaching, and lack of resources, the bill rather focuses on centralizing power into the hands of the state, which, as time and time again, have seen that everything they touch in the system seems to be broken. And disempowering parents and communities that know what is best for their children, rather than empowering them to ensure that they are able to facilitate education, quality education for their children, and make decisions on behalf of their children and their children's futures. So there is absolutely no way that we could support the bill in its current form. The second thing, Chair, is that we've got a constitutional obligation as members of parliament, as representatives of the people, as legislators, people that are responsible and entrusted to make the law, to ensure that any law that we make as a parliament, we are involved in meaningful public participation or public involvement. This particular process has been completely devoid of making sure that there's meaningful public participation or public involvement, views that have been taken into consideration by this committee. We've seen this by a report that has been put through that had so many discrepancies that did not include over 9,500 submissions that had to result in us staging a walkout in protest of the fact that we're not meeting our constitutional obligations. And again, we're proven to be correct to do so because the committee itself backtracked on that decision to adopt that flawed report and make sure that all the submissions that were needed to be made were analyzed. Including that, those submissions, despite them being analyzed, there was no qualitative and quantitative analysis of those submissions, even though the report has indicated that majority rejected the BELA bill. Because submissions in its form, and the reason why we get involved in public participation, is to make sure that we are seen to be influenced by the views of the public. And I can almost guarantee you 1,000% that those particular views that were analyzed did not influence us as a committee. Instead, a matrix was run through that is not inclusive of those submissions that were made by the public, written submissions, whether they were petitions, whether they were written submissions on email or the Google form or whatever form there was no quantitative and qualitative analysis of those submissions, and they did not influence us in any way. Meaning that we've also missed our constitutional responsibility to make sure that every single public submissions as been given by the legal opinion are included in the matrix and ultimately are seen to have influenced us as a committee as dealing with the bill. You can see it in the A list and the B list in this current form that none of those submissions have been seen to influence us as a committee. So there's absolutely no way we could endorse a process that is flawed, that will definitely be challenged on a legal basis, as well as a constitutional basis to make sure
that the public involvement and public participation is taken into consideration. So there's absolutely no way we could support that, inclusive of why we reject the bill. On the substance of the bill, it may be important for us to understand that the reason why we wanted to ask questions to the advocate Ngema at the time, to make sure that we understand her input on the B list, is, for example, that if you look at clause 4 and 5 that deal with admissions and language policies, that it is not indicative of whether if the HOD may approve or may not approve a policy. And I think in law, we need to get that clarity because it seems like it's hanging in the air. But I want to speak on the principle of centralizing power into the hands of the state versus making sure that we decentralize power into the hands of communities and parents. There's absolutely no way we could support clause 4 and 5 that seeks to give the HOD power to determine admission and language policies for schools. Because first and foremost, there's going to be an administrative burden for the HOD to approve all the public school policies of over 24,000 schools on average in the country. And you're dealing with 9 HODs in different provinces that are responsible for approving those policies for the different schools. So that's one, an administrative burden. But secondly, you're giving the HOD final authority to determine admission and language policies over the parents and communities that know what is best for their children in those schools. We are using law to scapegoat the failures of the current government, where there are not enough schools that have been built that have good quality education, that can provide mother tongue education so that I can study maths in my Xhosa or life science in my Xhosa, but are trying to scapegoat the 1,200 schools in the country for the failures of the current government in place. Yet they have not created any form of policy, let alone have implemented laws that have already exist in the country to make sure that a child that is born in Tsolo or Engu Junior Senior Secondary School can get the same good quality education as a child that stays in Mhlanga. And that is where the key and the crux of the problem is. And that's what the BELA bill is not addressing at this point in time. The admission policies and the language policies of the schools are used as a tool to be able to scapegoat these failures. And ultimately, what should exist is that if a school uses their admission or language policy to try and exclude a learner, then a recourse mechanism must be created and put in place so that those parents can be able to appeal. But what we should never do as a parliament is to make laws for the exception. Because if we make the laws for the exception, we can never stop at any point because there are too many exceptions for us to make laws for. The third thing, Chairperson, is that for us to be able to enhance good quality education, we need to make sure that we enhance mother tongue education. We must be able to provide mother tongue education in all of our public schools. We've got 11 official languages. We've got sign language now that is infused in our system. And what is important is that our schools must be able to provide that if I want to study in my mother tongue, that must be provided for. But what we should never do is take away the constitutional right for schools or parents to choose for their children to be studying in a single mother tongue education school. And that is basically what the BELA bill is trying to scapegoat. And we are continuously trying to point fingers at other people, whereas we should be pointing fingers at those that are currently in government that are failing the children of this country, particularly in rural and township communities that are not afforded that opportunity to study in their own mother tongue education. The fourth thing, Chairperson, is that this particular bill in its current form centralizes power to the hands of the minister in various forms, taking away the constitutional responsibility of provincial departments as a decentralized mechanism in education to ensure that we make decisions closer to the people, and taking some powers of MECs and HODs in provinces and giving them to the hands of the minister, which in itself is centralizing more power. And we are giving unfettered power to the minister to make determination of how many SGB members can be at a special school and who those SGB members are in that particular special school. And that is something that is really questionable, including that some powers have been taken away from MECs into the hands of the minister to make determination of how to run provinces. Yet we're supposed to be decentralizing power, but we're centralizing power into the hands of people that are already failing the education system. So the mistake we could ever make, Chair, is to make laws because we've got good people in mind. We must make laws for good people in mind and bad people in mind who are failing the system and those that are able to contribute to the system, so that we make sure that whatever checks and balances exist for those people to be able to protect good quality education for our schools. The fifth thing, Chair, is that homeschooling or home education has been completely ignored in these submissions. If we are seen to be influenced by the submissions of the public, we must be able to consider the fact that home education has indicated to us that they have not been thoroughly consulted. And ultimately, they are not opposed to the fact that home education should be regulated. But the manner in which home education should be regulated should be through reasonable means, should be protecting the rights of parents and learners, their constitutional rights in doing so. And this BELA bill has completely failed in passing that muster. And I can almost guarantee you, with these pointers that I've raised of the fact that we're centralizing control and power on admission and language policies, on the fact that the minister is getting unfettered powers, and the fact that the home education sector has been ignored in terms of the inputs will definitely be challenged. And the second last thing, Chair, that I want to raise is that this BELA bill itself is missing. There's what we call a legal lacuna that exists in this BELA bill. COVID-19 has showed us that online and blended learning has become the thing of the day because learners were studying from home and they used devices and gadgets, yet we are failing to regulate online and blended learning or put legislation that is inclusive of online and blended learning as a mechanism of education, which could also alleviate overcrowding in schools. It can also provide an opportunity for parents to be able to teach their children at home, but also for the state to start being innovative of making sure that children, despite of their backgrounds, whether they are poor or they're affluent, they are able to access online and blended learning by providing the resources that is available and is needed for them to be able to access that form of learning. So, Chair, in its current form, the Basic Education Laws Amendment Bill, process-wise, content-wise, qualitatively and quantitatively, cannot be supported by the DA. In fact, it is rejected. Thanks, Chair.
Thank you very much. Any other party?
Thank you, Chair. Shall I proceed, Chair? And thank you for your kind indulgence. I've got to think enough to continue. Shall I continue, Chair?
Yes, you may.
Chair, the ACDP rejects the BELA bill in its entirety. And for the record, our submission in terms of our minority report has already been delivered more than a few days ago. We reject the bill because the ACDP advances and advocates for parental rights and opposes state control in education. It is the primary responsibility and right of a parent to decide on the education of their children, whether poor or rich, whether urban or rural. Education should be provided where the child resides, where possible, as this is optimal. And by closing rural schools, we are in effect undermining the rights of rural parents and rural communities. Public participation should be meaningful and effective to give effect to the principles of participatory democracy. The process of lawmaking with this legislation exposed both the incapacity of Parliament to give effect to this principle and the constitutional obligation of members to ensure effective participation and give meaning to the voices of people, whether we abide by that. It is our submission that these principles was lacking in application, both through the incapacity of Parliament and the failure of the committee to give due consideration for public comment. The failure to optimally ensure that homeschoolers' comments are included in this legislation is failure to remain open and a failure to hold the department accountable for the lack of effective consultation with this community. And in so doing, we are in effect not doing our duty to oversee this department. These failures are likely to doom the bill being struck down, as was warned by my predecessor, Honorable Dudley, and by the presentation that I attempted in the beginning of this process to make to the committee in terms of enhancing the public participation process. The ANC has run an expensive exercise that will merely have to be redone. The BELA bill undermines the aims of creating competent communities rather than a bigger state. The incapacity of the state to deliver on the most basic of services and the poor educational outcomes proves that the principles of solidarity and subsidiarity that should be applied in the reform of education. The state must not do what communities can do. And closing rural schools and putting children in mega schools rather than driving innovation in education through diverse models is a failure by the department, and one which this parliament, through this committee, then allows to continue. We cannot support the BELA bill. It is an administrative bill that gives more jobs for officials, and it is a bill that undermines the rights of parents, and in effect, it ignores the best interest of the child. Thank you.
Thank you very much. Any other party? At once?
Thank you very much, Chairperson. I hope that I'm audible because I'm under load shedding. Am I audible, Chair?
Yes, you are audible.
No, thank you very much, Chairperson. As the ANC, we support the bill in its current form. The BELA bill, Chair, has been deferred since the fourth administration because of continuous engagement with stakeholders, continuous consultations, processes that were unending. So it is not true that there was not enough consultation that was done during the processing of this bill. Chair, the BELA bill seeks to amend certain sections of the South African Schools Act of 1996 to respond to administrative challenges facing our schools and to continue with the transformation agenda of our education system. It is not a wholesale bill that covers all aspects of the sector, as it is alluded to. We hear that issues of infrastructure has been raised that are not even part of the bill. It focuses mainly on the administrative processes of the department and the schools. Chair, you'll agree with me that this bill responds to current needs in terms of the changing demographics of our communities, and also responds to the findings by the courts that the department has faced with. It also responds or even legalizes the ECD shift that was implemented, as now the grade R is compulsory and it has not been legislated. So this bill will also respond to that. Chair, it is unfortunate that this bill is highly contested due to the transformative systematic shifts it proposes on various critical aspects of the basic education system. Our education system still has elements that perpetuate discrimination due to language and spatial policies. The bill is processed at a time when the country is polarized on the various matters of social cohesion, and the political climate of election contest further fuels the narratives and contradictions of the process. You would remember, Chair, when we went through the public hearings, you would think that we're in elections because community members were, or those that attended were really in the election mode. Some of the things that were raised were really not even about the bill. The bill has been misinterpreted in many areas, and it is based on questioning the department capacity and capability to implement some policy reforms effectively. So those were some of the observations that we made, Chair, but as lawmakers, we are expected to make laws. Even though there are certain processes that we follow pertaining to this bill, I don't think there's anything that we have left behind. As the committee, we received this bill. It was presented to us, and after the presentation by the minister and the department, this bill, we made our own schedule on how to process the bill. We agreed on a time frame of written submissions. We even extended the time frame because we felt that not all the corners of the country were reached, or properly communication was not done, and then we extended the written submissions. We also engaged with the stakeholders on oral submissions, and also we went through the public hearings. The views were considered in the deliberations during clause-by-clause discussions, where the department was invited to clarify all the clauses. In the consideration of the written submissions, yes, there was an omission of some of the written submissions that were not counted. But as the committee, you keep on saying we're a nice committee, Chair, and I agree with you. We did request that all those written submissions and all the voices of community members or public must be heard, and the views were counted. And I must say, Chair, the presentation that we received from the content advisor in our last meeting was that the views that were read there really were not even talking to the clauses that were presented in the bill. Were hailing insults, mentioning of a certain political party, and there was no content in what was presented to us on those views that were oral submissions that we made. And we're happy that all those processes have unfolded, and we're happy that now we are concluding on the bill. Chair, I think what has been presented
Have we lost the whip now? Or am I lost?
It appears so, but we can finish the job that she started, if it pleases Your Majesty, my Chair.
Whip, are you gone? Let's allow you to finish, Principal. Principal, are you also gone now?
No, I'm available. Are you giving me space? Okay, thank you.
Looks like she's
Thank
gone.
you, yeah, no, thank you. In the ANC, we complement each other. especially during this moment of load shedding and whatsoever. Chair, as an addition on top of what the Honorable Adwans was busy articulating, it is very important, equally important, that we need to demystify some misconceptions as the African National Congress and the lie that is being peddled here by both DA and their half-sister ACDP. It is not going to be correct, Chair, to mislead and misinform the public that the BELA bill, it's projecting or is saying nothing about the curriculum failure as raised by Honorable Nodad. From time in and time out, we were told that the bill has got nothing to do with the curriculum. So when we round up to come and mislead the public that the BELA bill is misinformed with regard to the curriculum and not addressing issues that matters, is totally being out of order. I was full of respect. I should have interjected him when he talked about the issue of the curriculum. It is neither here nor there. On the issue of the mother tongue being compromised, as raised by Honorable Nodada, it must be very clear that in South Africa, there is no mother tongue which is better than any other mother tongue. When we talk about inclusive education, where our kids are being segregated on the basis of the language they speak, we are not talking fallacy, but facts, which are predominantly being practiced in provinces like Gauteng and the Western Cape. So the mother tongue here is not for purposes of depriving any nation of its identity. It's a misconception, which misconception must be corrected. With regard to the powers of the minister, as raised by Honorable Nodad, you see where he is indicating that the minister is given the powers to control almost everything, which is something unnecessary according to him. It must be indicated to the ACDP and to DA here and now that South Africa is a unitary state. And there is no way in which we can, as the governing party, try to say we can decentralize power to an extent that the minister will not be able to have control. We do not, and we are not prepared to create any other republic in the form of the Republic of the Western Cape or the Republic of Cape Town, wherein people can do and practice something different, which is alien to the center, which is led by the minister herself. The center must hold as enshrined in the Constitution. The last point, which we will add as the African National Congress, maybe it is around the issue of homeschooling. You see, from time and again, and also in their submissions, they keep on saying there was not enough consultations. Chairperson, we view this as mischievous, as misleading, and also unnecessary fallacy from the opposite bench that there was no consultation. We were given a very clear presentation of a series of meetings where the department reached out to homeschoolers as they tried to find each other But unfortunately, if people are not willing, there is nothing to do in order to try and bring them closer to you, except that we have got all the right to enforce the Constitution on the provision of education to everyone, and also that homeschoolers must be registered. That is a constitutional imperative. For people to say there was no consultation, it's a lie, it's a fallacy, it's misleading, and we are not going to accommodate that. Maybe let me wrap up by saying, Chairperson, it is about time that there must be change. The sunset clause, time is over. We have suffered, is enough. We tried to reach out. It's very regrettable that people are not prepared to be reached out. I repeat what I said yesterday, and if given space, I will repeat it even tomorrow. Change is inevitable. Change is pain. Change is unavoidable. Change on this bill or change on this, the SASSA, is a formidable must. I thank you, Chairperson.
No, thank you very much, Honorable Morwa. Can I check if the whip is back? Thank you very much to all the members. Honorable Adwans, are you back?
No, I'm back, Chairperson, and my apologies. I have a very bad network here.
Okay. Any other party? No other party, we done. So now I am going to ask the members that we adopt the BELA bill as drafted. And in us adopting the BELA bill together with the committee report, we are sending it now to the National Assembly for the National Assembly to do its work on the bill. As the committee, it's our last day now dealing with this bill. As from now, we are taking the bill to the National Assembly with the inputs that have been made by the political parties. And I repeat that minority parties do have provision to send their views on the bill. There is a hand of the principal. Principal Rotsetla.
My chair, my name is Ronnie. My father's name is Muratsetla, a member of this all-important portfolio committee on basic education. I rise to move that this draft bill be adopted with all these additions and amendments that have been infected into it, be adopted and further be taken to the National Assembly for the final adoption. Thank you very much.
Honorable Morane.
Thank you very much, Chair. I hope I'm audible because I'm on load shedding. And greetings to... Okay, thank you, Chair. I must indicate that I want to second that we adopt this BELA bill, and also to appreciate the indications and the deliberations that have been made by my colleagues, even on Honorable Adons before she was cut off, that it is indicated clearly how important is this bill and how important it needs to be adopted, more especially because it illustrates all the grey matters that they were raised in terms of the pre-registration, that it's not going to be invasion in terms of the assessors going to check what is happening. I think I want to support fully so that it be adopted today. Thank you very much, Chair.
Thank you very much, Honorable Boshoff.
Thank you, Honorable Chair. Now I put my hand up before the suggestion was made by Honorable Morwachela. I wanted to suggest or to say that the committee should reject this bill and put that to the vote. But as there is something on the table already, I would just vote against it when the time comes for it.
Now you want us to vote, Honorable Notat?
Chair, please note the objection of the DA to the BELA bill and the report that has been submitted thereof. So just please make sure that those objections are noted. Thanks.
The DA objects. Can I put the BELA bill on the vote? Those who support the BELA bill, can they raise their hand? Those who support that we must send it off to the National Assembly. Llewellyn, can you count the hands that are up? If you know that you've got a voting right, you vote. If you know you don't have, you don't vote.
Thank you, Chairperson.
Can you equally indicate the names of people who are voting for and those who are voting against, because he might omit some of us.
It's fine. Llewellyn will do that. Thank you, Principal.
Thank you, Chairperson.
On the bill now.
Can you speak, Llewellyn?
Chairperson, I currently have hands in favor of the bill. Honorable Morwane, Honorable Madlingozi, Honorable Aduans, Honorable Yabo, Honorable Morwasetla. Have I missed out anybody? And
you are forgetting the name. There is a hand of Honorable Litsie.
Thank you very much. I have Honorable Morwane, Honorable Madlingozi, I have Honorable Aduans, Honorable Yabo, Honorable Morwasetla, Honorable Mbinko Gigaba. I am not seeing the hand of Honorable Letsie for some reason.
Because it's not up.
Yeah, it's not up.
All right. Can we allow the members who vote against the bill to raise their hand? And please, the others to lower their hand.
Yeah, mine is down completely.
No, Chair, you can let them leave it up, Chair.
The severity of load shedding in the coming months and ultimately to end load shedding altogether.
Somebody between
what is happening
somebody between Van Zyl and Van der Walt is not supposed to be voting.
That's me, Chair. Am I taking my hand down?
Yeah, and close your mic.
Letsie,
Yeah,
you are not. Letsie,
where
are you
were you?
voting
You did
against
not
the
vote.
bill?
His hand is up, Chair. It's fine. Keep it there.
Letsie,
No.
are you voting against the bill?
Please don't manipulate, Chairperson and Honorable Morwasetla.
No, you must be given space to air his views, man. There is nothing wrong in
He
this.
was not in the platform when he voted, so he must be explained to what is happening now. Chair, can you please explain to him?
If he's not on the platform, he can't vote. Well, can't do that.
No, you can't do that. A vote was closed. That's the rule.
Can you count the
No,
vote?
no, no, no,
Then
no,
you
no.
can,
There was no
order,
closer.
order, order. This is still my meeting. Please.
Yeah.
Order. Can you count
Chairperson.
the
Chairperson, those against the hands I have are Honourable Sukers, Honourable Van Zyl, Honourable Nodada, and Honourable Dr. Boshoff. He's an alternate member. Thank you, Chair.
Honourable Boshoff, you are not supposed to vote.
Yes, I'm not voting. Actually, yes, my hand is up, but I tried to just to
Can you
level
take
my
it down?
objection
Can
because
you
I
take your
cannot.
hand down?
Okay, it's down.
Thank you. How many hands do we have? 3.
Chairperson, I only have 3 hands, Honourable Sukers, Honourable Van Zyl, and Honourable Nodada. Thank you.
3 against what?
Against 6.
We have 6 for the bill and 3 against the bill, Chairperson.
Thank you very much. The 6
Chair,
have
can I
it.
please?
We are
Chair, can I
taking
please
the
request?
bill to...
Can I please
Can I
request, Chair,
finish?
that-
Can I finish?
Okay, sure.
Thank you very much. The 6 have it. We are sending the bill to the National Assembly. And like I have said, we have noted the views from the minority parties. And I would ask the staff to please add those views as attachments to the National Assembly. Honorable Nodada?
Oh, thanks, Chair. You've covered me in the first point. The second one, can I please request that the minutes must reflect who the members of the committee have voted for and those against? Thanks, Chair.
Hi, Suga.
What kind of a goal do you want to
That's
score?
not important.
No, please.
Can you take us to the minutes, Llewellyn? Thank you. Note that your hand is up.
No, it's irrelevant.
The leg at the end. Sorry, Chair.
Thank you very much. These are the minutes of the 12th of September.
Have you recused the officials, Chairperson?
No,
Or were
they
you
know
overwhelmed?
they must be recused or they can stay. These are the minutes of the 12th of September. We were deliberating on the BELA bill, B2, and the matrix and consolidated BELA bill report on submissions. And then we considered the minutes of the 8th, 15th, 16th, 17th, and 19th of August. Page 1 is the attendance of members. Page 2 is the officials, DBE, and Parliament. We have opened the meeting and welcomed everybody. And then we were dealing with the matrix. And then we considered the amendment into the A list. And then in respect of the agenda, members deliberated. And then the agenda was moved by Honorable Muratsetla and seconded by Honorable Adwons. And then for the record purposes, the DA, the ACDP have objected to the agenda. And then we have presentation of the national report, which was done by Ms. Mbudem Chekwane, as presented. And then we had a presentation on the draft matrix, which was also done by Ms. Mbudem Chekwane. Or just to say that the report was objected by DA and ACDP, and also the matrix was rejected by ACDP and the DA. And then we have considered and adopted the amendment A list. And it was moved by Honorable Litsi and seconded by Adwons. And then for record purposes, the DA and the ACDP They have objected also the A list. We then considered the minutes of the 8th of August, the 15th of August, the 16th of August, the 17th of August, the 29th of August, and the 5th of September. And all those minutes have got their movers and the seconders. And then we have concluded by asking for a moment of silence for Honorable Buthelezi. And then we have alluded that the committee meeting will be held visually to formally consider the Basic Education Laws Amendment Bill, as well as the committee report. The bill and the committee report will then be tabled in the National Assembly as required. And then we agenda the meeting at 13:20. Any corrections? Principal, are you correcting? Principal?
Chair, I'm sorry. I pressed the button to move, and because I didn't want to correct. You can jump me for now if you want corrections, but you'll call me when you want a mover.
In the absence of corrections, can we adopt the agenda, the minutes?
Now is my time. Mudula Tudo, Riemele Lamu, on behalf of myself, to move that this minute be adopted as a true reflection of what transpired on that day in question. Thank you very much.
Any seconder? Let's see. Honorable Tia?
No, thank you very much, Chair. I second the father. The son seconding the father for the adoption of the minutes.
You vanished in a moment of need. You are
no, they cut off my network. They cut off my network.
In a critical moment of need, he vanished.
Yes.
No,
my son
no,
was
I'm investigating.
Your
I'm
son,
investigating,
and I know
that.
you are going to defend him.
Yeah.
I'm investigating,
no,
not that.
Yeah.
No, I'm
He was
investigating,
bewitched
not
by
that.
no one.
Yeah. It's not that.
All right.
Investigating seriously.
The next minutes were on the 19th of, was for the meeting of the 19th of September. It was a Zoom meeting. We had a briefing on the exam readiness by the department. Page 1 is the attendance. Page 2 is DBE. Is attendance and the parliament's attendance. We have opened the meeting and welcomed DBE together with Umolusi. And we have just indicated that we are going to have a meeting on the 26th, which will consider and finalize the bill, which we asked members to attend, though we know that it was the constituency. The meeting was moved by Honorable Itzia and seconded by Honorable Adwans. And then we have allowed the presentation by the department, which was done by Mr. Unyaka and Dr. Polia. And then the presentation by Umalusi was done by Ms. Matalane. Those are committee observations and questions to both the department and Umalusi. And we had responses from the department and Umalusi. We have considered the minutes of the 19th of September, and then we have agreed that the next meeting would be on the 26th of September. And the meeting was adjourned at 13:45. Any corrections? Honorable Itzia? In the absence of corrections, any adoption? Can we adopt the minutes?
Chairperson, Madlingozi. Yes, I rise up to adopt the minutes of the 9th September 2023. Thank you, Chair.
Thank you very much. Any seconder, Honorable Morwane?
I second, Chair.
Thank you very much, Siyabonga. Members, thank you very much. Thank you very much once again for your time. I must say that it's appreciated that you did attend this meeting during constituency period. Just to mention that when we come back, we've got 8 weeks for the next quarter. We will have 8 weeks for the next quarter, and the draft program will be sent to you in due course, so that you see what likely does the program look like. And then we are going to meet when we reconvene in the next quarter. May you have your hand is up, Honorable Moerane. May you have a lovely constituency period. Thank you so much. The meeting is adjourned.
Myself and my investigating officers were investigating, not that. Thank you.
Thank you, sir. If they beat you, the English says if they beat you, you join them. You can't defy that natural law of justice. Thank you.
Recording stopped.